Welcome to Conveyancing Matters. This is our July 2023 news edition. Welcome to Conveyancing Matters with Lorraine and Stu. Join us for a chat about all things property. So, welcome to Conveyancing Matters. And the first thing you might notice is that I'm flying solo this month. So Stu's got quite a lot on his plate, and he's actually off on his hollybobs, lucky man. So I'm going to do the July 2023 Conveyancing Matters news for you. Hopefully, there's again a usual sort of potpourri of interesting things for us to talk about. A couple of things I'm actually going to mention which aren't necessarily yet on the statute books, which might be coming. Generally speaking, as you know, Stu and I try very much to keep our news confined to, things that are already bothering us as conveyancers. But I do think there's one or two things you need to be looking out for. But I would say one of the most important things you need to be looking out for, of course, is the Conveyancing Matters subscription service, where Stu and I offer quite a lot of conveyancing related content. There's access to the Conveyancing Matters live events, and of course we put out a unique and exclusive new webinar each month just for our Conveyancing Matters subscribers. We've done 3 or 4 now on the Building Safety Act. We've done new builds. We have got coming up auctions and all sorts of other things, and we've had a request from a subscriber to do a webinar on completion. So there's a lot coming up on the subscription service. So do go to www.conveyancingmatters.co.uk, find the subscriptions. It really couldn't be easier. You just pay online, and you've then immediately got access online. You set up your own username and password. It really is as easy as it could possibly be to give you immediate access to everything, including the past webinars. And it's only £40 a year for an individual subscriber and £150 a year for a firm. If you want to subscribe monthly as an individual, you can for £3.95, but actually the £40 a year is hopefully pretty good value. So it would be great to have you join us. And of course, as I've said, you as Conveyancing Matters subscribers, you do get sort of free access to our live events. And just to give you a little heads up, the next one in London in November is now booked. So we'll be putting the date out and giving you more information in due course. But we'll definitely be coming back to London in November. So we really hope to see you there. But anyway, so again, the usual sort of potpourri of news issues that are relevant to us as conveyancers. And one of the first things, just to remind you really, is that for those of you who do sort of dip your toe in the shared ownership pool, note that Homes England has updated the 2021 to 26 model leases. So the model leases have been updated. The model leases are now found in the section 5 of the Homes England Capital Funding Guide page, and there are sort of certain fundamental clauses that must be included in shared ownership leases and in model leases. So frankly, some firms can choose to use their own leases, but frankly, why would you when you've got the model leases? But do make sure that you are clear about the sort of key fundamental clauses that got to be contained in there. But I say just note for interest that the model leases have been updated. And just like buses, you wait a long time for something, and then 2 come along at once. So we've also now had the Court of Appeal comment on shared ownership leases, and the question raised was whether a shared ownership lease that was granted for more than 21 years is a long lease for the purposes of the Common Hold and Leasehold Reform Act, where the tenant's share is less than 100%. So is something capable of being a long lease despite the fact that irrespective of the tenant's share on a shared ownership lease. And it perhaps isn't surprising that the Court of Appeal concluded that yes, a shared ownership lease is absolutely a long lease, irrespective of the percentage of the share that the tenant holds, meaning that every shared ownership in the block in question was a qualifying tenant for the purposes of the 2002 Act. And therefore, and the court sort of observed, and the Court of Appeal sort of said, well, Parliament cannot be taken to have intended to restrict the unqualified ambit of the Act by adding a paragraph purporting to widen rather than narrow the definition of long lease. So basically, irrespective of the percentage of the share that a tenant holds in a shared ownership lease, it's capable of being a long lease, meaning that under the result of the decision was that the right to manage company in that case had acquired the right to manage. So it's a bit of a niche point, but nonetheless it's always useful to and I think it's always important to sort of comment when the when the Court of Appeal speak, really. Just note that the Law Society has published some guidance on the UK sanctions regime. So the Law Society has published some guidance on that, and it provides, and remember, the sanctions regime is sort of wider and of much wider ambit than the sort of, just the sort of pure sort of AML regime. So the sanctions regime is potentially of much wider ambit and impact on firms more generally. But do remember, the Law Society has produced some guidance, and it gives guidance on things like criminal offences under the regime, how to carry out a risk assessment, sanctions lists, acting for clients on a sanctions list, and reporting obligations. Now, it's fair to say that that's perhaps unlikely to affect, conveyancers at the coalface who might be watching this, but, you do need to have that sort of broader awareness of those sort of, AML sanctions and sort of regulatory issues. And there's been a lot in the press, of course, about mortgages and mortgage pain more generally. Of course, we've got a bit of a perfect storm in a way, in that property prices are plateauing a little bit, interest rates are going up. Now, frankly, when you're as old as me, I hate to say it, but it was always evident that interest rates could never stay at the historic low rates that they were at for the last few years, and we've had that sort of property price boom. Well, when property prices go up, they always come down. So I see interest rates going up at the moment, and property prices coming down as more of a sort of equalization of the market rather than anything more dramatic, I have to say. But of course, the problem is that lots of people are going to be coming off their sort of fixed rate mortgages, perhaps, 2 and 5 year fixed rates that they took at those historically low rates, and they're going to be coming into a market where, mortgage interest rates are much, much higher, and therefore families on, as most of us are, fairly sort of static incomes, are actually going to find that additional mortgage payment requirements very difficult. And of more relevance, I would suggest, to property litigators, but the government and the lenders have sort of come up with a sort of understanding on lenders' requirements around repossessions in the state of the current market. So, as I say, they have come up on that. But what the government, and this is what's of interest to conveyancers, I think, is that they're also mooting with the lenders. They are thinking about the possibility of 40-year mortgages. And again, on one level, that might not affect us as conveyancers at all, but remembering, and one of the most important things I do try and remind people about what we can, as conveyancers, can tell our clients about mortgages, is that we can only give generic advice. We can only say, this is your mortgage offer, this is what a capital, this is what a repayment mortgage means, this is what an interest-only mortgage means, this is what your mortgage offer says. We can give generic advice, but what we cannot do is give specific financial advice. So if a client says to you, is this a good interest rate? Is this a good deal? And frankly, in the current market, they're more likely to be saying that. It's very important for you to understand that that's not comment or advice that you should be giving, and you should be sending your client to an independent financial advisor or mortgage broker, because the very simple fact is you're not qualified to comment on, you know, the suitability or otherwise of mortgage products, or, you know, we can't say yes, you know, bank X or building society Y have got a good deal on at the moment. But the sort of possible heralding of the 40-year mortgage, you'll certainly find a lot of commentary online and in the property press from mortgage brokers, some of whom think it's well, one chappie from Daryl Doffer from the Mortgage Expert said it's a bonkers idea and means more interest. And, you know, he points out with a 40-year mortgage, you'll be paying more interest for a longer period. It means you'll end up paying more interest overall. And it gives an interesting example. For example, if you take out a 40-year mortgage at 4% interest on a £200,000 loan, you'll pay £140,000 in interest over the life of the loan. If you take a 30-year mortgage at the same rate, you'll pay £108,000 in interest. So a really big difference. And he also said you'll build equity slower too. So, but there are other brokers that think it's a good idea. Our job as conveyancers is not to pass an opinion on a 40-year mortgage. If you ever see a mortgage offer of that in those terms, our job is to really point out in you know, in big letters, the length of the mortgage term, to point out to the client whether early redemption penalties are paid, which is highly likely, and one wonders whether with a mortgage with a longer term, whether early redemption penalties might run on for longer. So, for example, you know, it's going to take longer for the lender to recoup their debt. So are the lenders going to impose early redemption penalties for longer? Quite often the early redemption penalties are payable you know, on a sort of normal mortgage if the borrower redeems within the first 5 years, but maybe with a 40-year mortgage, the lenders might impose early redemption penalties maybe in the first 10 years of the mortgage, which, you know, would be quite significant for many people. So just look out for them. They may or may not happen, but remember, your job is not to pass an opinion on it. It's to make sure the client understands the implications of it. Now, as a trainer, moving on, I don't necessarily want to advertise other people's training products because I'm nothing if not selfish. However, give Land Registry its due where it's, you know, where it's where it's justified, because the Land Registry has just released its essentials training package for new conveyancing staff. And as you know, Stu and I had Mike Harlow on in January of this year of 2023. We had a very wide-ranging chat with Mike, and you know, it got a lot of views, which was great, and a lot of interest. And hopefully we asked some of the questions that conveyancers wanted asking of the Land Registry around, you know, why is it taking so long to process applications, and, you know, this is making life difficult for conveyancers and so on. The Land Reg has announced a recruitment drive, and to be absolutely fair, the Land Registry, you know, is trying to provide support for conveyancers to sort of assist with things like reducing requisition rates. But what the Land Reg has also put out, which I think is a very, very good idea, and firms ought to know about it, and there'll probably be a lot of you watching that might find this useful, but they've put out a sort of training package of various products and bits and bobs on the Land Registry's website for people perhaps relatively new to conveyancing. I have to say, though, I suspect that there's quite a lot of us who would watch this and have something to learn. So you know, I think it could be useful for a lot of us. So they've put out things like a video on what the Land Registry does. They've put out how the Land Registry fits into the conveyancing process video. So it's, you know, videos, which is great. On-demand application workshop comprising 6 webinars. So they've put a little, you know, you can look through how, you know, avoiding requisitions, you know, restrictions, execution of deeds, you know, variation in names, a fees flow chart. There's webinars on calculating fees. There's, I think, what might be a very useful thing for people looking at the elements of a title register, so property proprietorship and charges, and a general link to the Land Registry's training hub. So, as I say, absolutely credit where credit's due to them. I suspect there's a lot of very, very useful resource there for conveyancers of all levels of experience, and of course it's free, so good for them. Now, as I mentioned at the beginning of this July 2023 news session, generally speaking, Stu and I will only talk to you about law that's already in force, because frankly, as conveyancers, I think you've got enough to be thinking about without worrying about things that might never come onto the statute books. And maybe this that I'm going to mention is one of those things, but do just remember that the government is always talking about sort of planning and house building targets and all the rest of it. That's become a very political hot potato. And actually, do you want to know my personal opinion on all this? And it's not political in that sense. I think, and the government might want to pick this up, or somebody can come and talk to me about it. I think all infrastructure type issues, long-term planning projects, housing, roads, rail, dare I say utilities, all of those long-term infrastructure products that involve billions of pounds and long-term, way beyond the life of a particular parliament type issues, they ought to actually be taken out of the political arena. They ought to not be sort of political hot potatoes, just to be, for blows to be slugged between the main political parties. I think you ought to have sort of almost all party committees comprising, representatives from all parties in Parliament to deal with those long-term infrastructure planning projects, because so many things get started as a political baby of somebody or other, and then of course gets ditched, a few £billion into the project planning. So that's that's my personal view. Just thought I'd share that with you. But 24th of July, the government announced plans to build 1 million new homes over the life of this parliament. Haven't we heard that before? No date has been put on that time frame, so there may be scepticism by a lot of people, but of course it is going to impact on conveyancers. It is introduced, and really just note that developers are going to apparently be asked to contribute more through fees to help support a higher quality, more efficient planning service. Let's look at the success or otherwise of developers paying to remediate unsafe cladding. How well's that going, lads? Watch out for this, because again, if it's introduced, it's very much going to impact on you. New flexibilities, and I quote the government's press release here, to convert shops, takeaways and betting shops into homes, going to help rejuvenate the high street. So you can maybe get your kebab, go to the pub and go to bed all in the same building, very possibly. Red tape will be cut apparently to enable barn conversions and repurposing of agricultural building and disused warehouses. So this is all sounding like putting people in industrial buildings, isn't it, that weren't built to house people. New freedoms to extend homes, convert lofts and renovate new buildings, and convert existing properties into new accommodation. And a review into the extension of permitted development rights. So please do just keep an eye on that, keep a watching brief on that, because if that's introduced, it will probably be incremental, but nonetheless, it's going to impact on you day to day, pretty much from the get-go. What I found most, and I haven't looked into this, so I could be just talking nonsense here, but apparently a new super squad of leading planners is going to look to unblock major housing developments, and the team will first be deployed in Cambridge to turbocharge our plans in the city, quote the government. And I just think, well, of all the places in England that need turbocharging on the planning front, I'm not sure I'd have picked Cambridge first, if I'm really honest, but there we go. What do I know? But another planning issue for you to watch out for, and as I say, I'm conscious of not telling you about stuff that may not be introduced, but this is enshrined in a bill which is on its way through, might still be ditched out. But remember, a planning change to watch out for, which will be important if it's introduced, is that the current 4-year enforcement period is going to be phased out and replaced with a 10-year enforcement period. It might never be passed, but as I say, it is currently in a bill that's sort of staggering through the parliamentary process. And as of course by way of recap, 4 years, it's an important period for planning and of course conveyancing purposes, because basically, in a nutshell, unlawful development can be made lawful once they've been in place for at least 4 years. And of course, the way that would impact on us most immediately as conveyancers, of course, is if development, which of course, remember, under Section 55 of the Town and Country Planning Act, prima facie requires planning permission. But if development takes place without the appropriate planning permission, or deemed planning permission under permitted development, then the local authority essentially have 4 years to take enforcement action. And once that 4 years has passed, the local authority's ability to take enforcement action lapses. So, you know, extensions, even a new building, you know, a new garage, whatever, you know, certain boundaries, whatever. There's a lot that impacts on us, and lots of you will get, you know, indemnity policies to take account of that. But just keep an eye on that, again, on the progress of that. Because if some people get their own way, that 4-year enforcement period will be in place replaced with a 10-year enforcement period, meaning that clearly it's going to take a lot longer, and we as conveyancers are therefore, you know, going to have more planning problems, and it's unlikely, I would suggest initially, that you'll be able to get indemnity insurance within that first year 10-year period for enforcement, because of course the indemnity insurers say, well, there's still the risk of enforcement, you know, we're not going to give you a policy. To be fair to them, I'm sure they'll develop products if something happens, but that 10-year enforcement period going up from 4 is really going to impact on us as conveyancers, because you are going to be faced with a lot more situations where, you know, something has been built that should have had planning permission that didn't, you know, and you know, a 10-year period to deal with as part of the conveyancing process is a lot more difficult than 4. So watch out for that. Potentially more pie in the sky, but common hold still keeps, I mean, common hold has always been with us, of course, but since 2002, you know, it's the alternative really that's being mooted to leasehold, because of course, for all the reasons in the world, leasehold has become pretty toxic, hasn't it? And again, you know, I think somebody on the Labour front benches has sort of pledged to abolish leasehold in the first 100 days of the Parliament if they're elected. You know, and you do think, oh, has nobody learnt anything from the Building Safety Act debacle? You know, Michael Gove said a couple of times, oh yeah, let's abolish leasehold. Oh, that's quite difficult, isn't it? Oh no, let's not abolish it. Common hold is there. I think it keeps being reported as sort of, you know, being in the wings. My view has always been with common hold. I mean, I always took the view that once it was quietly dropped from the standard conditions of sale back in 2011, I felt that was its death knell for a while. But as a means of home ownership and, you know, dealing with those positive obligations in the sort of flat apartment type scenario, it's always been there. I suspect that there might be an element of compunction that has to be introduced. Otherwise, it's not going to be used, because I think the death knell first time round was when the big developers didn't pick it up. Then it didn't happen and just fell by the wayside. So watch out for common hold. It could still make a comeback, and there are certainly sort of mumblings in the property press about that. So we might have to get to grips with common hold, you know, as you know, even now. I find this odd, really. The Land Registry have put a little update in Practice Guide 67 on evidence of identity, which is, of course, important for conveyancers. But interestingly, their latest update tells us that they've amended Section 8 to clarify that firms should always use the current versions of our ID forms. Well, you kind of would have thought that firms would do that, but what that implies to me is that the Land Registry is getting quite a lot of ID1s and so on forms that have been superseded. So for goodness sake, the ID is absolutely central, isn't it? Particularly if you've got an unrepresented party. So you do not want the Land Registry rejecting your application for registration if you're submitting an ID form that's out of date and the Land Registry is saying this isn't acceptable form of ID because of the version of the form that is used. So I think that's particularly important where you are saying to a party whom your firm doesn't represent, you know, go to another firm and get an ID1 done, or do it yourself. You should just be making sure that the correct version of the form is used. And again, really, as with sort of transfers and the idea now that we're looking at signed transfers before completion, I suggest you're asking to look at an ID1 that you're going to be presenting to the Land Registry to support your application for registration. You might just want, as a belt and braces, to be looking at that ID1 before the matter completes, so that if the ID1 is incorrect, as in it's not the right version of the form, or indeed it's just not being completed correctly, you can say, terribly sorry, wrong version of the form, we're not going to complete. until you give us the right one. So just watch out for that, because clearly I would suggest, and I don't know, I'm just surmising, but I would suggest that in feeling the need to put that in, which seems a bit obvious, the Land Registry are clearly coming across lots of out-of-date ID forms. And remember, they've only got a shelf life, a fairly short shelf life anyway. I thought an interesting point that was actually reported by today's Wills and Probate. They had picked up on some research by Quilter. And I just thought was sort of, relevant to conveyances in the broader context. Don't want to make too much of it, but we obviously see lasting powers of attorney a lot as conveyancers, and particularly when we're acting for a buyer, it's, that can be risky. There's a lot of issues around powers of attorney, making sure that they're properly certified, looking at the extent of the power. Has the seller's conveyancer got ID for the holder of the legal estate as well as the attorney, so that you can confirm that on your application to the Land Registry. There's a lot going on already. But this organisation, Quilter, did a freedom of information request to the OPG and found out, and as I say, today's Wills and Probate picked up on this. Apparently, there were over 29,000 rejected LPA applications made to the OPG, which brought the total rejected applications since 2018 to 127,848 LPAs that were rejected. So I think it's really, really important that you check the LPA carefully, that you do the appropriate search, which is free, to make sure that an LPA is properly registered. I just thought it was an interesting stat that's a significant chunk of applications to register LPAs that are rejected each year. And of course, the other side of that coin is that this data request by Quilter revealed that on average in 2022 to 23, it took 91.5 days to register and dispatch an LPA application, which, as today's Wills and Probate remind us, is over 4 months. And the longest period was 983 days, where it was necessary to refer to the Court of Protection, which was, of course, over, a long old time. So just watch out for that, because of course, if you are, for example, acting for a seller and an LPA has been entered into, and your seller client is, going to sell with the assistance of an attorney, and that LPA hasn't yet been submitted to the OPG or has only just been submitted, it's fair to say, assuming the application goes well and there aren't any queries and it's not rejected, it's still perhaps going to be sort of on average some 4 months or so from the date of the application for the LPA to be registered. So that's a long time in conveyancing terms. So if your client rushes off to market, without the LPA formally registered and in place, that could lead to quite a lot of delay and disgruntlement. So I think it's really important that you, particularly if you're acting for the seller and that LPA is to be registered, that you keep those thoughts in mind, really. So there have been, really, just to conclude this news section, more Building Safety Act updates. As I say, we've now done 4 Building Safety Act updates and videos and webinars for our subscribers. So if you're interested in those, then subscribe away, because you will have access to stuff we've already done. But in terms of sort of news, well, as I'm sure you're aware, there's a new set of regulations teetering on the brink, which are going to sort of update the Act before it's even fully come into force. And one of the main changes there are suggested changes to the landlord certificate. And the lenders are changing their requirements almost as often as some of us change our underpants. And you might be interested to know that a friend of the show, lovely Rob Hailstone from Bold Legal, his conference back in June, they did get a brave member of government to attend the conference, to sort of walk into the lion's den, being faced with questions from conveyancers on the Building Safety Act. And to be fair and there were quite, and perhaps unsurprisingly, a lot of questions that the person who turned up to the conference couldn't answer. Well, Rob has now got a set of answers from that, from the Department for Levelling Up. And if you're a Bold Legal member, then go and find it, because Rob has now put that those series of questions out. So, you know, they have come back with answers on, you know, certain landlords aren't willing to include the leaseholder protections. You know, what's the government doing about it? You know, how are conveyancers supposed to know or confirm the height of buildings? There's lots of important questions in there that that Rob has now got some answers to. So go and find those if you're members of Bold Legal, or you know, dare I say, if you're not, go and subscribe to Bold Legal. So I hope that's been just a useful little scoop through some of this month's news, some of the things that are affecting us right now, and I think some quite important things that, if they come into force, are going to impact on us as conveyancers, particularly in relation to the planning issues. So, as ever, thank you very much for watching. I really hope that you found that useful. Hope to reintroduce Stu next month for our news. So I hope you haven't missed him too much. I have, obviously, and as ever. If you're interested in subscribing to Conveyancing Matters to get conveyancing content, webinars and promotions and other bits and bobs, then please do go to www.conveyancingmatters.co.uk. Thanks for watching.